Law School. I'm one of the teachers here. Through Bill Clutter, who I'll introduce in a moment, this seminar was arranged. I want to, as much as you have the bios in front of you, this is being videotaped, audio taped. The tape and DVD, along with the PowerPoint presentations, will be available on the website that I'll give you in a moment. And so I'm going to spend a couple of moments to introduce these speakers for the benefit of the video audience. Bill Clutter is a licensed private investigator who began his career in 1985 working as a law office investigator for Springfield criminal defense attorney Mike Metnick, who many of you probably know. During that time, he was part of the defense team that went on to free Rolando Cruz. He's been involved in a multitude of other innocence cases and has in fact begun an innocence project. If you look at the back of your programs, the Investigating Innocence is a new innocence project that Bill started within the last number of months. Prior to that time, he was working with the Innocence Project for the University of Illinois. He's a phenomenal investigator. His wife is a mitigation specialist who we've used in many capital cases around the country. Bill started this program. He is responsible for the program being organized today. He's going to talk to you a little bit about the Vaughn case in Joliet, in which he was intimately involved, and some other cases. If you want to join the Investigating Innocence Project, the application form is on the back of the program, and the benefit of joining is Bill has just told me that the DVD will be made available to those people who sign up and become members of the Investigating Innocence. If you want to spend $25 separately for the DVD, you can do that, but if you want to join the program and get it free, it probably makes much more sense and has the money going to a worthy project. Keith Altman is a practicing attorney working in civil litigation. Keith is the gentleman seated at the table next to Bill Clutter. Before he became licensed as an attorney in California, he worked as the director of adverse events analysis for Finkelstein and Partners in New York, specializing in lawsuits against the pharmaceutical industry. He's testified as an expert witness for the defense in the South Carolina case of Christopher Pittman, which he'll be talking about this morning, the so-called Zoloft defense, and has some extraordinary insight both as a lawyer and as an expert in the field of pharmaceuticals that he's going to share with you this morning. David Healy, who will be here shortly, is an internationally respected psychiatrist, psychopharmacologist, scientist, and author. The books set forth in the program, among other things, the creation of pharmacology from Harvard University Press, antidepressant era. He's got 200 other pieces and 20 books. He's also testified in numerous cases. His main area of research is clinical trials in pharmacology, the history of psychopharmacology, and the impact of both trials and psychotic drugs on our culture. He's been involved as an expert witness in homicide and suicide trials involving psychotropic drugs and in bringing problems with these drugs to the attention of the American and British regulators. He's also a professor of psychiatry in Wales, and he'll be joining us in about an hour or an hour and a half. With that, I just have a few remarks that you should be aware of as the basis of this program, or in part as the basis of this program. In 2006, the Illinois Supreme Court came down with the decision People v. Harry, H-A-R-I. You can find its site at 218 Illinois 2nd, 275. It was a murder case, and it involved an attempt to use the issue of whether or not the defendant was involuntarily intoxicated as a defense. Interestingly enough, if you look at the involuntary intoxication statute, and I see many in the audience are familiar with insanity defenses in the state of Illinois, the involuntary intoxication defense still has both prongs that the insanity defense was used to have until it was taken out. Those prongs are a person who is intoxicated or drug conditioned is criminally responsible for conduct unless such condition is involuntarily produced and deprives him of substantial capacity either to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law. That statute is at ILCS 5/6-3. As I said, interestingly, with respect to the insanity defense as a result of John Hinckley, the first prong was taken out, able to substantially conform his conduct to the requirements of the law. That was taken out. It still exists with respect to involuntary intoxication. What happened in the Harry case briefly is that there was an attempt to rely on involuntary intoxication. Mr. Harry was only using prescribed medication. His contention was he had unexpected and adverse effects from the prescribed medication and consequently should be able to rely on the defense of involuntary intoxication. And the issue was whether or not taking drugs that are prescribed allows you to rely on involuntary intoxication as defense. Most of the cases prior to Harry said no, because you voluntarily took the medication, you're warned about the potential consequences, the adverse impact, you're responsible for it. We all know with respect to DUI cases, as an example, if you're driving under the influence of Benadryl as an example, and you start falling asleep, you're potentially liable for any of the consequences of your falling asleep because you took a drug that you know causes sleep. What if you take a drug that you don't know what the consequences are, or the consequences are unexpected and adverse, and you're not warned about them by the doctor? And that's exactly what happened with the Harry case. He took prescribed medication. He was not warned about potential adverse consequences of mixing that drug with Tylenol. It was mixed with Tylenol. It caused adverse consequences. He contended that it had an impact on his ability to understand the criminality of his conduct or to conform his conduct to the requirements of the law. He submitted an instruction. He was denied the right to submit the instruction, went up to the Illinois Supreme Court, and they reversed. And in 2006 said, if you have unexplained adverse consequences, unwarned adverse consequences of prescription medication, involuntary intoxication is a legitimate defense. And so it's an extraordinarily important case. I want to bring to your attention one other case that you should be aware of, and that came down in 2011, People versus Gregory McMillan. That's a 2011 ILAP first 100366. That was the first district case coming out of 2016 California out of Judge Lynn. In that case, the defendant attempted to rely on involuntary intoxication as a defense. The problem with respect to Mr. McMillan, unlike with respect to Mr. Harry, is Mr. McMillan was mixing prescribed medication with street drugs. Judge Lynn refused to give an instruction under Harry. The defendant was convicted, took it up to the First District Appellate Court. The First District Appellate Court said they are not modifying in Harry at all. Harry obviously is the law. They don't have the ability to modify a Supreme Court decision. What they do have the ability to say is that Judge Lynn was absolutely correct. If you mix street narcotics, street drugs, with prescribed medication, involuntary intoxication is not a defense. It's just wiped out because of the mixing of the non-prescription medication. And so, as far as I can tell, that's the latest case with respect to this particular issue. What I want to do is turn the program now over to Bill Clutter. Bill Clutter is going to talk extensively about the Vaughn case in Joliet, the fact of potential adverse effects on the wife who was the victim, and whether or not she is potentially responsible for the killings of which Mr. Vaughn was convicted. There's also some special guests that Mr. Clutter is going to introduce to you right now.
And again, as I was saying, I want to thank Richard Kling and Kent College of Law for hosting this. I met Richard back in June of 2000. I was introduced by Dave Protus, and I think it was Manny's that we had lunch, and was able to persuade him to represent an individual named Herbert Whitlock pro bono, along with Susanna Ortiz. And through their work, Herbert Whitlock is a free man today after spending 21 years in prison for a murder he didn't commit. I worked on the co-defendant's case, Grady Steidel. He had received the death penalty. He got post-conviction resources under the federal law that created the capital litigation unit that Andrea Lyons ran. And at the time I was involved in that case, I was working for Mike Metnick, who pro bono represented Alejandro Hernandez, who was the co-defendant for Rolando Cruz. So, you know, my roots go deep in this issue of innocence, and it's proved to, impact policy, particularly with the death penalty. And I'm here today to talk about a case that had been a death penalty case, the case of Christopher Vaughn. And that'll be one of the cases that our new project will undertake. We currently have two cases that we're working on, three where we had Vaughn. We have the case of David Cam in Indiana. It's one of the most outrageous cases of actual innocence, where a former police officer has spent 12 years in prison for the murder of his wife and 2 children. DNA and a palm print that was at the crime scene, ignored by police investigators, proves that a career criminal committed this murder. That wasn't discovered until 5 years after David Cam had been convicted. It's on second It's on his second remand to second trial, third trial. And that case is scheduled for trial in August. And so I was retained as a blood stain expert. And as I said, it's our featured case. If you go to our website, you learn more about the case. I think we have handouts. I want to recognize our executive director, Kelly Thompson, who's our executive director of this new project, and Bridget Norris, who's working on the CAM case as a student intern. She's a criminal justice major at the University of Illinois at Springfield. Moving to the Vaughn case, I'd like to introduce Jerry Killian. Jerry was the attorney who represented Christopher Vaughn for about 3 years in Joliet. He was a capital qualified attorney. Under the Supreme Court rules, he was had co-counsel with another attorney, John Rogers, in Clayton, Missouri. And I also want to introduce Gail Vaughn, Christopher Vaughn's mother. Thank you for being here. And I got to say, when I first got involved in the Vaughn case, I was court appointed through John Rogers, an attorney from St. Louis. I worked with him on other cases in Springfield, Illinois. And he called me about the Chris Vaughn case. And of course, I was aware of the Vaughn case. It happened June 14, 2007. The Vaughn family were traveling to Springfield, Illinois, where I lived, to go to a water park when this happened. Many of you know the story of the case. But for many weeks, I was, when Jerry Killian would tell me that he believes Chris Vaughn's innocent, I looked at him and I'm thinking, really, this is going to be a sentencing case, isn't it? And, Jerry was very convinced that Chris Vaughn was innocent. Of course, he had watched the video interrogation by police, and it wasn't until that point that I started analyzing Christopher Vaughn's statements that I became convinced that he was innocent. And you'll see some of the forensic evidence that helps support that. But when you have a case where you suspect medications may have influenced suicidal behavior or even homicidal behavior, the first step is to, prove the causation. I mean, was the person taking the medication? And if you have a suicide, as you have, that I contend in the Vaughn case, it was proven through the toxicology and autopsy. Kimberly Vaughn was taking 2 prescription medications, tryptolene, which is an SSRI. Keith will tell you more about that. By those drugs, you want to go to the labeling and medication guides to see what warning label, what the FDA requires the manufacturer of those drugs to warn in terms of side effects. And then the next level of investigation, of course, is to consult with somebody like Keith Dalton to give you the FDA adverse events database and what those numbers show in terms of causation. You conduct a psychological autopsy, the state of mind of the individual. And there's various ways of doing that. And the one that I have a special interest in is crime scene reconstruction. And it really wasn't until we did the crime scene reconstruction, the Vaughn case, that I became absolutely convinced in his innocence. This was a photograph taken literally days before this happened. Kimberly Vaughn had graduated from, but you can see this was a beautiful family. Christopher Vaughn was making $200,000 a year as a forensic computer consultant for Navigate here in Chicago. He relocated the family from Seattle, where he had been a private investigator. He purchased a gun when he lived in Seattle, 9mm gun that was actually used in this tragic event. But he, by all appearances, this was really, the all-American family. They lived in the suburbs in Oswego. But part of Christopher's job was he traveled all over the country doing investigations for major law firms who consulted with Navigate. And it really was analyzing Christopher Vaughn's statements to the Illinois State Police. He was, they got up early in the morning, they were going to the water park in Springfield, and his wife started getting nauseous, which was a side effect of her migraine headaches. She was taking the combination of these 2 medications to treat stress-related migraine headaches. And she'd been taking these drugs for a little over a year, When she started feeling nauseous, she asked her husband to pull off to the side of the road. He pulls off at the bluff exit, just south of Joliet, pulls along the frontage road and pulls the vehicle in front of a cell phone tower. And of course, it was very early in the morning, where there's a 911 call. There's a person on their way to work early in the morning, and he encounters Christopher Vaughn limping down the frontage road, and he'd been shot twice. The first shot was to his wrist, and according to the crime scene investigators of the Illinois State Police, this was a shot where it deflected off a very heavy silver watch and went out the driver's window. The second gunshot wound was actually through his jacket. There was a hole in his jacket in the front, and it passed right over his groin area, into his left leg, out the leg, into the driver's door of the vehicle. And so the Illinois State Police crime scene investigator was able to get a pretty good trajectory. And his opinion was that Christopher Vaughn was kind of leaning toward his wife when that shot was fired, based on the trajectory. He initially tells the person, when the person asks, were you in a motorcycle accident? No. What happened? The first statement Chris makes shortly after this occurred was, I think my wife shot me. And then he's transported by paramedics to the hospital in Joliet. The paramedics note that he's going into shock. When he gets to the hospital, they're asking him about insurance, and he says, well, ask my wife. She should be here any minute. And for the whole interrogation, it's evident when you watch it, the video, is that he has no idea that his family has been shot and killed. And it's not until police confront him with the crime scene photos that he realizes that. And he has no memory of what happened when he's interviewed by the state police. And when they keep giving him the opportunity to blame his wife, he says, there's no way she could have done it. And really is that video interrogation that convinced me and others that he may be actually innocent. And as I began investigating this, and we're having our litigation meetings in Joliet, I started researching the DSM-4, and there's dissociative amnesia, which seemed to fit what we have here. It's a form of memory loss. It's caused when a person witnesses a severe traumatic trauma-producing event. And the example they give in the DSM-4 is if someone were to watch their entire family killed in an automobile crash, and they were the sole survivor, that would be an example of the type of trauma that would produce dissociative amnesia. And in this case, you have, his wife who's dead and 3 dead children. And the police are, interrogating Christopher. Well, what do you mean you didn't hear the gunshot? No, I didn't. I don't remember hearing the gunshot. What do you don't remember how your kids got killed? No. You don't know how your wife got killed? No. And it says in the DSM-4 that the memory could, it may come back over time or not at all. And in this case, it was, I think, the second day of interrogation that when the state police are pressing him, do this for your children. We need to know. They tell us what happened. And they're putting him on the spot and pressuring him, appealing to, the memory of his children to tell us what happened. Fill this in for us. And he has a fragmentary memory where he says he looked over after he gets out of the vehicle when his wife was nauseous. He gets back into the car, and he says when he got into the car, he looks over and thought, I saw a gun. But he says, I know that was impossible. Why does this kid have a gun? And it was like my mind shut off. I froze. I looked down and my leg was bleeding. And that's where his memory stops. Because to remember more would be so traumatic. I couldn't imagine what the events that happened inside that vehicle that day. But that's all he remembers. And there's a thing called freeze response, where a person that witnesses trauma, experiences trauma, your brain shuts down and it freezes. And we were consulting with an expert who was going to possibly testify about that effect, because this was a death penalty case and we really had resources to work with. But then it was really the bullet trajectory in the case. And this is when This occurred in Joliet. They actually had the vehicle stored at the old Joliet prison. So it was a cold, I think maybe February. It was freezing cold, and we went into an enclosed area of the prison, which was now abandoned. And we had our own crime scene expert, Tom Bevel, from Norman, Oklahoma. And we're making the first inspection of the vehicle. And Tom Bevel notices that there's a trajectory. It penetrated through the body of the middle child, Cassandra Vaughn. It went through the seat and into the next seat behind it. And it provided 2 points of trajectory where you could determine where that shot had been fired from. And the shot that killed Cassandra Vaughn, based on the trajectory, and we actually had to borrow a dowel rod from the Illinois State Police. This is something that they didn't do in their own investigation. They arrested Chris the day of the funerals of his family. And just a matter of days, it concluded he did it. And it really is, when you analyze this case, it's a classic case of tunnel vision. They disregard any evidence that would seem to challenge their belief that he did it. And this is the trajectory that Tom Bevel came up with. And this is our expert, Luke Haig, who's an expert in firearms. He actually attached a laser pointer to that trajectory and actually demonstrated, and you see the green tip at the tip of his finger, where that shot came from and where it was fired from. And this was the scene that the Illinois State Police encountered, and there are a number of assumptions they made about the crime scene that later turned out to be false, including the basis of probable cause that led to the arrest of Christopher Vaughn. Because when they came to the crime scene, Kim Vaughn had a gunshot wound, a contact wound, according to the autopsy, just under her chin. And she was found in this position. There was no evidence that she had been moved, because you see the stream of blood coming from her mouth. So there's no evidence that her body had been moved after she had been shot. And then when you analyze the blood evidence, it appeared that she had been leaning down when that shot was fired, because the blood came straight down onto her. She actually had a towel that the gun had been wrapped in. And you can see a blood pattern, blood trail, where she's leaning down when that shot is fired, and then slumps to the position you see her here. And the police, the paramedics, they find her, and the seatbelt is unbuckled, and they find blood on the seatbelt, and they assume that there must have been some evidence of staging, because it appeared that that seatbelt must have been buckled at the time she was shot, and somebody unbuckled it. And they inferred that it was my client, Chris Vaughn. And you can see this huge amount of blood here on the console, and that would be exactly where the buckle would clasp to the seatbelt clasp. And this was the blood, and you see the stain of blood on the seatbelt. They assumed that that was Kimberly Vaughn's blood, and the belt had been unbuckled and staged. And then when they pulled it out, the crime scene investigator pulls it out, and inside, concealed in the frame of the vehicle, was this large pattern of blood that had to have been caused, in their mind, by Kimberly Vaughn slumping over and bleeding onto it. That was the assumption that state police had. And this was, in fact, what they put in the crime scene report. That when they had another female crime scene investigator sit in the vehicle, buckle the seatbelt, there's exactly where that pattern of blood appears, is right above her chin. And so again, there was this shooting from the hip, making these assumptions without doing the DNA. But this was the grand jury testimony of Sergeant Gary Lawson on July 25th that formed the probable cause. They had already arrested Chris, and now this was their probable cause, other than him being the sole survivor. The assumption was he must have done it. Why, he's got these superficial wounds. Why is he still alive? But this was really the basis of the probable cause, and that was the testimony that when paramedics found the seatbelt, it was unbuckled, there was blood on the seatbelt, and questioning. And that is significant because she was wearing that seatbelt when she was shot. Yes, that's correct. Well, it turns out that DNA testing invalidated that probable cause. DNA testing by the Illinois State Police Crime Lab invalidated it. They tested it on the buckle where it buckles, and on that portion that you saw that was visible in the crime scene videos, or photos, But that report was issued 2 weeks before Sergeant Lawson testified, and then it was marked at the top, draft, and then it wasn't released until the day after he testified to the grand jury, which seemed odd, right? So we file a motion, Jerry Killian, John Rogers, file a motion that we should have all of that blood tested. And when we did, on February 19th of 2010, the results were that it's all Christopher Vaughn's blood. And what that meant was that that seatbelt had been buckled at the time Chris was shot here, which was a headshot that deflected off the watch, and here, where that was a shot, I wouldn't have taken that shot. I'm self-inflicting. You know, I was literally within that far away of hitting his man parts. And yet, when you analyze the blood evidence, it's really the bloodstain pattern analysis that completes the story of what happened at this crime scene. And that proves that Kim Vaughn unbuckled her seat belt after her husband was shot. And why did she unbuckle the seat belt? Well, this is what shows. This is what, in bloodstain analysis, this is what you call a transfer stain. It's a transfer stain on her right thumb. If I'm holding a gun and I extend my thumb and depress the seat belt where there's blood on it, we know there's blood on it because the state police said it's Chris Vaughn's blood. You would get that type of staining pattern from a transfer of coming into contact with a bloody object. And in fact, what you have, when you look at the other side of it, is there's evidence of a white mark. There's a blood wipe, consistent with what you see on the thumb, the transfer stain. Came from unbuckling the seatbelt. That's something that she did, not our client, Chris Vaughn. There was no evidence of staging of the crime scene. And in fact, and it really wasn't until we started doing depositions, because, you know, it's interesting, now that the death penalty's gone, you know, how many have access to depositions in criminal cases in Illinois? None of you, right? And but for the deposition process, we probably wouldn't have known the truth, because he certainly didn't volunteer it when we interviewed him without deposition, but when we put him under oath, the crime scene investigator from the Illinois State Police unloaded. And he described how he was getting pressure from the state's attorney and from his investigators and from his superiors to basically confirm their preconceived theory that Christopher Vaughn committed this murder. And he was telling them, no, wait a minute, let me do my job. Let me process the crime scene. We haven't even finished processing the crime scene before you jump into that conclusion. He says, none of these theories you're offering are supported by the crime scene evidence. And he said, every time I would come up with something that the evidence would suggest or support, or you'd be able to at least follow the evidence to come to a logical conclusion, basically I was just given some other crazy way that this could have occurred. Or they would change their theory of what happened to try to match the evidence rather than letting the evidence dictate to you the events that occurred. Sounds an awful lot like tunnel vision, right? And this is another crazy theory. And this came through deposition. Again, this was a deposition of a forensic scientist from the Illinois State Police Crime Lab in Joliet. She described how the state's attorney was convinced that the barrel of the gun had been forcefully jammed underneath Kimberly Vaughn's chin. And it was based on their interpretation as lay people, not scientists or forensic scientists or anybody experiencing gunshots, that this, they call it a snowman, this soot impression under the bottom of her chin meant that this gun had been shoved under her chin by force. Well, what this actually shows is evidence of suicide. It turned out when we interviewed, took the deposition of the forensic pathologist who was the state's witness. He described this as loose contact. And he said, yes, that's consistent with the self-inflicted wound. He was under oath. Jerry Kling took his deposition. Months before, this was literally just weeks before Governor Flynn signed the bill abolishing the death penalty. We learned what happened at this crime scene. And of course, he described this, Dr. Larry Bloom, he described this snowman, soot, basically being caused by the gun barrel just being placed there and fanning out and creating that snowman effect. Not by force, but by loose contact. He said it was not indicative of force, not at all. Didn't show that at all. He said it was consistent with self-inflicted wound, consistent with suicide. And of course, you know, the Governor's Commission, some of you may have worked on some of the 20 death row exoneration cases here in Illinois that led to the abolition of the death penalty. When the Governor's Commission met and analyzed these cases, they, you know, tunnel vision occurred in most all of those cases. And they described and went on to define tunnel vision, which is exactly what we have here in the Vaughn case, where once they make that conclusion, you know, they just marshal the facts and assemble the evidence to try to fit it into their theory of the case. But this is what forensic science says about that loose contact wound. A contact wound favors suicide. Quote, a chin entry wound tends to be self-inflicted. And of course, this was, when they did the autopsy and reconstructed how the gun was positioned, this was the way it was positioned. In this is an article, and it's in my PowerPoint. If you want to read more about this article, but it basically says that you want to look for blood evidence. In a self-inflicted wound, the way this gun is positioned, you would expect to see, and I don't know if you can see the arrows here, but it's on the left hand. They've got two arrows pointing up and down. This is the pattern of blood staining you'd expect to see in a self-inflicted wound. And you can have both backspatter, which is a misting of blood, and also passive drops from being over the wound. And in this case, we had evidence. This blood on her left hand, on her left thumb, is exactly where you'd expect to see it if it was a self-inflicted wound. And the gun was found exactly where you would expect to find it if it was self-inflicted. I mean, a lot of people, when they're staging suicides, they'll put the gun in the person's hand, right? Well, the gun falls immediately. And the crime scene investigator for the Illinois State Police said there was no evidence that gun had been placed there or staged. It fell exactly where it dropped, or dropped exactly where it fell. Does that make sense? Okay. And so here we get to the toxicology. And the Illinois State Police were aware from Dr. Mitchell's autopsy that there was Topamax, and this is the generic name, and nortriptyline that she was taking. It was a cocktail of medications she was taking to treat stress-induced migraine headaches. And it's interesting because it was the state's theory of the case that when they questioned Christopher Vaughn, they're asking him, were you all stressed out? Were you stressed out? Is this why you did it? But here you have a subject who's taking these medications because of stress-related migraines. The Illinois State Police started to do what should have been a proper investigation in terms of keeping your mind wide open when it comes to these cases, because the crime scene investigator listed Kimberly Vaughn as suspect number 1, and he listed Christopher Vaughn as suspect number 2. And if you're not operating under tunnel vision, you should be conducting parallel investigations to see where the evidence points. And in this case, you have to rely entirely on the forensic evidence, because Christopher Vaughn can't remember hardly anything about what happened. But they went ahead and they based on the toxicology and autopsy that she was taking 3 medications, Avapro, I think for high blood pressure, Topamax, and nortriptyline. But they were looking for, in these subpoenas, for anything in her medical records that might, quote, indicate suicidal or homicidal thoughts or impulses relating to Kimberly Vaughn's prescriptions for and utilization of the drugs referred to as Topamax, Avapro, and nortriptyline. And they got the medical records. But it wasn't until a year or more after this happened in June of 2007, but in December of 2008, the FDA issued an alert, a warning, about the increased risk of suicidal thoughts and behavior for patients taking the drug Topamax. Topamax was among 11 medications total that were normally prescribed as anti-seizure medications for epileptics, but it also had off-labeling use for treating migraine headaches. The FDA found that there was a statistically significant risk of suicide associated with these medications, and Of the 11 medications, Topamax had the highest odds ratio when they compared the data. And Keith will tell you more about what that means. Significantly, on May 24th, 2007, this was maybe 3 weeks before this happened, Kim Vaughn went to see a new doctor. He was an osteopath. And the reason she went to see him is because osteopathic medicine apparently doesn't rely on drugs. It relies on herbs and vitamins and things like that. Natural stuff. So apparently she didn't want these medications. And she has as her chief complaint her, quote, evaluation for onset of anxiety. And I would submit that the records, the medical records the Illinois State Police subpoenaed do show, are relevant, were important, if you put everything in context. The problem is nobody knew about the FDA alert until after they arrested Chris Vaughn, well into his death penalty defense team preparation. But this becomes significant, the anxiety. Because one of the things about the medication guide that was changed in the labeling warnings for Topamax was that you're supposed to call your health care provider right away if you have any of these symptoms. New or worse anxiety, feeling agitated or restless, panic attacks, new or worse irritability, other unusual changes in behavior or mood. And there had been some anecdotal evidence from family members we interviewed on Chris's side, where during a family outing in Missouri, Kim became very stressed out because she had to turn in a homework assignment for her online class. She couldn't get the Wi-Fi working, and she had a total meltdown, a total panic attack that was witnessed by family members, some of whom are here today. So there's some of these red flags popping up, both in her medical records and through observation by witnesses. This was the email she sent to her husband after she went to her osteopath, probably that afternoon. She said her doctor told her, quote, stopping migraine medication will also help stop my anxiety, unquote. So that doctor realized there was a possible side effect of her medication that was causing her anxiety. And we now know through the medication guide that Topamax does exactly that. And that's something that you have to be concerned about as a physician if your patient is starting experiencing any of those symptoms right away. But that medication guide didn't exist at the time she went to that doctor. And she said, quote, I told him that you had noticed, and I had noticed, a big personality change and anxiety change, and that I was lethargic, tired all the time. That was her email to her husband. And of course, if you follow the case, the prosecutors try to use all of these emails going back in time to show that she was in a happy frame of mind, that she wasn't suicidal at all. And that was a battle, I think, that was lost after the defense team that was in place got dismantled. So these are the other side effects on the medication guide and labeling warnings. Quote, effects on thinking. Topamax may cause depression or mood problems, tiredness, and sleepiness. This was exactly the same thing she self-reported to her husband on May 24th, 2007, 3 weeks before herself and her family were killed. And it says, acting aggressive, being angry or violent is another side effect. And this didn't appear on the medication guide or warning labeling until May 9th of 2009, when it was required by the FDA. Acting on dangerous impulses, another side effect. This again comes from the medication guide and labeling of May 9th, 2009, from the FDA warning label on Topamax. Quote, how can I watch for early symptoms of suicidal thoughts and actions? Quote, pay attention to any changes, especially sudden changes in mood, behaviors, thoughts, or feelings, unquote. Well, again, this was literally in the last days of the death penalty in Illinois when we were able to use the tool of depositions where we subpoenaed Dr. Badia that had prescribed both medications, nortriptyline and Topamax. And when Jerry Killian conducted that deposition and asked Dr. Badia about that email that she sent to her husband. And this was what he said. He said, a big personality change would be an unusual change in behavior or mood. And he was asked, and this is what he said. He said, compared with what I knew about Kimberly, yes, that would be a big change. And Jerry asked him, he said, but with the big personality changes that she self-described, that would, and then he finished the sentence, that would be significant. Yes. And so this is all evidence that we're mounting and developing as part of our defense of Christopher Vaughn. And I've got to tell you, I've been doing this for now 27 years, and this was the most complex criminal defense case I've ever worked, including the Nicaraguan case and others. Because you're involved, you're really on the frontier of science in terms of the side effects of these medications. You're going to hear from one of the world's leading experts later this afternoon, Dr. David Healy. Both Dr. David Healy and Keith Altman, whom you'll hear from, were both retained experts on the Vaughn case. Dr. Badia then was asked about the synergistic effects of taking nortriptyline, which is an SSRI. You'll hear more about that because that already had a warning label, I think maybe a black box warning label as well. Keith will explain it to you. But again, this is another medication that's recognized as, causing possible depression for depressed people, and has a risk of suicide as well as Topamax. Dr. Badia was asked what would be the significance of taking both medications together, and his response was, quote, well, it would increase the risk of suicidal thoughts, unquote. And unfortunately, I don't think any of that evidence got effectively presented at Christopher Vaughn's trial, because what happened is, this is my former client, Randy Steigel. This is the end of the Capital Litigation Trust Fund, effectively. When Governor Quinn signed the bill to abolish the death penalty on March 11th, I believe it was, 2011, thank you. It's interesting because the bill sponsors pointed to Randy Steidel, my former client in the gallery, and said, this is why we're abolishing the death penalty. Well, that's good news. But the bad news is, for people like Chris Vaughn, who were facing the death penalty, the bad news is you lose the resources to defend yourself and improve your innocence before trial. That was the whole intent of these reforms. Supreme Court Rule 416, the right to have depositions in the death penalty case, to get to the truth, to prove innocence before trial, to have the resources to retain experts like Keith Altman and David Healy. And so after the abolition of the death penalty, the defense team was effectively dismantled. There was an attempt to get funding through the county. There was intense resistance, and Jerry may be able to speak more about it, but we were basically discharged. And so we had worked that case from 2007 until 2011. And so collectively, the two attorneys, myself, and the experts all had a body of knowledge of the details of the case. And so then a new team comes on, and the jury was out, 30 minutes? This should have been a case where there's reasonable doubt. I mean, this is a case where there needs to be more scrutiny, more review. And one of the reasons, that I founded the Illinois Innocence Project 13 years ago because of my work with Larry Marshall and Rob Warden and others. But this is Christopher Vaughn's life today in Menard. It's hard to talk about this because, we're standing on the sidelines and watching this ship go down. And more could have been done. And more can be still done. And I mentioned Richard Kling providing pro bono representation to someone like Whitlock, or Mike Metnick, who provided pro bono representation for two death penalty clients, Alejandro Hernandez and Randy Steidel. But for Mike Metnick, Randy Steidel, I don't think would be a free man today. he's going to require post-conviction resources. It's one of the reasons we formed this new project. It's a case that I personally feel strongly about. And so we invite you to join our new organization. You can become a founding member at 500. You can become just a regular member at 25, or in between, whatever you choose. But the benefits of membership are seminars like this one today, and to be able to help cases like this, either in a small way or a big way. And if you know other attorneys who might have an interest in learning about this program today, recommend they go to our website. If they join and become a member, they'll get a video of the program and can earn CLE. But I want to thank everybody for attending today, and I'll entertain questions if you have any. Thank you.